The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. We'll hear argument in our first case, 21-4299, United States versus Lee. Counsel, whenever you're ready.
Thank you, Your Honor. May it please the court, Nick Giles on behalf of the appellant Austin Lee. Before the district court sentenced Mr. Lee, it ruled that an enhancement applied on 2 of his 5 counts based on a prior conviction for a serious drug felony. Now, applying this enhancement required the court to make factual findings that went beyond Mr. Lee's prior conviction and asked about his incarceration and even about the instant offense. And because these findings increased the mandatory minimums Mr. Lee was facing, they violated his Sixth Amendment rights under Apprendi and a lien. Now, the government agrees to this point, Your Honors. The government recognizes that these facts should have been determined by a jury and, in fact, asked the district court to include them on the jury form below. And the government similarly agrees that Almendarez-Torres doesn't apply here because the elements of a serious drug felony go beyond facts that are inherent to the defendant's prior conviction itself. Even so, the government asks this court to affirm because the admitted Apprendi error was harmless. Now, this is wrong under this court's decision in United States versus Leggins. Now, as this court recognized late last term in Leggins, harmless error in the Apprendi context is a narrow and demanding standard. What the Leggins court noted was the heavy burden that the government bears to prove harmlessness. And what Leggins says is an Apprendi error is harmless only when 2 things are satisfied. 1, the facts at issue must be uncontroverted. And 2, that the facts must be supported by overwhelming evidence. And I'm quoting from Judge Richardson's opinion in Leggins here, if there is any reasonable possibility that a juror might have chosen to convict, then the error was not harmless.
Okay, Mr. Giles, why isn't the proof of the missing element overwhelming within the context of the Leggins decision? Because here you have the defendant's statement that he spent over 5 years in the penitentiary and that he got out around, 2015?
That's correct, Your Honor. Those statements are on the record. I don't think those statements go to the question of whether the prior conviction had actually been vacated by virtue of his motion that he...
Right, but doesn't there have to be some proof? I realized that our case law had been talking about whether something was uncontested, and you're saying you're contesting it, but I think that was something that Leggins did. It clarified what uncontested meant, and saying that the proper way to perform a harmless error analysis in such cases is to ask whether proof of the missing element is overwhelming and uncontroverted. Well, isn't the proof here overwhelming since it came from the defendant himself?
Well, I don't think the proof is overwhelming, Your Honor, because nothing that the government offered in its proof actually goes to this question of vacatur or question of expungement. But even assuming that...
Can I just clarify? You're talking about a different part, a different element, right? So there's the fact of the prior conviction and that it, had a 10-year max, et cetera, which you have not contested, a judge can decide.
That's correct, Your Honor.
Then there's the duration of the incarceration and the recency.
That's correct.
Judge Keenan has pointed out you don't contest duration and recency. You're only contesting the element that you've already said a judge can decide. So why does that matter for what's in front of us?
Well, I think, Your Honor, that the argument that Mr. Lee put forward about a potential vacatur or a potential expungement, could go to those second and third elements as well. For instance, if a conviction had been vacated, I think there's an argument that his...
Well, that's your point, that there's having a conviction is a predicate to the time in prison having been legitimate, et cetera. But again, that predicate, you agree that predicate can be decided by a judge. So how does that render the other two issues that you say should go to a jury, how does that make that not harmless? I mean, if you admit the judge can decide validity, here the judge decided validity, and that's what you say is the predicate to the other two elements.
Well, I don't think it's a predicate to the other two elements, Your Honor. I think it's a three-part test where you have to satisfy all three elements. And we will concede that if it were just the first element, if it were just the fact of conviction, and that's what this statutory provision looked like prior to the First Step Act, we concede that can go to a judge without constitutional concern. But here you do have a three-part test. It has to be the conviction with a maximum sentence of at least 10 years, plus the duration of incarceration, plus, the recency, what we call the.
And you haven't contested the last two elements?
I think, Your Honor, that his argument about vacatur, fairly and broadly read, would go to those second elements as well.
Well, on the vacatur issue, in Nader, the court says it is enough to just contest. It's not enough to just contest the element, that there has to be sufficient evidence. What evidence do you have to support the vacatur?
Well, there would have been the defendant's testimony, Your Honor. And the defendant submitted a statement before the district court. The district court sort of, rejected that as a pro se statement at that time when, he was represented by counsel. Subsequently, at the 851C hearing, his counsel below did incorporate his position on that motion, Your Honor.
But he testified at trial to the conviction.
He did testify at trial to the conviction, but the vacatur issue was not at issue at trial, because those issues were not included on the jury form.
It seems to me, Mr. Giles, that maybe one of the deficiencies of your position is that a defendant could then contest by simply saying that conviction isn't good and that's enough. I mean, how can that ever constitute overwhelming evidence?
Well, I don't think, Your Honor.
Or uncontroverted evidence, just to have the defendant come in, because then under that theory, it seems to me you could never have harmless error. If the defendant contested the fact of the prior conviction and had no evidence, he would hold the keys to harmless error in his pocket and effectively keep the court from analyzing the evidence in the case.
Well, I think, Your Honor, we're talking about a very narrow set of cases, we hope, where a case where there is an apprendi error below. So by definition, we're talking about a case where, the defendant's Sixth Amendment rights were violated. But I don't think that's true, Your Honor. And I think if we look at both Nader and Leggins, we find cases where, the court has found the error was harmless. And those are cases in which the defendant chose not to contest the elements that are at issue. But I do think it's correct, Your Honor, that a defendant does have a right to put the government to its burden of proof on factual elements that it's required under the Constitution to prove to a jury. I don't think the Sixth Amendment, guarantees a right to a trial by jury on close facts or on difficult facts. I think it requires a right to a jury on all facts.
Right, but the government doesn't have to prove the negative, that the conviction has not been vacated. The government simply has to prove the fact of the conviction, plus then those other elements that follow.
They would have to prove the conviction and the elements that follow, again, beyond a reasonable doubt. And I think the defendant would have every right to stand there and hold the government to its burden of proof. So I do think, Your Honor, that if we read Nader and Leggins, at face value, that bar is quite low. The bar for what it means to be uncontroverted is quite low. And it's low for a variety of reasons. One, as the en banc Third Circuit has pointed out, there is a tension in ruling that apprendi errors can be harmless based solely on overwhelming evidence. Because as the Third Circuit put it, then, if we affirm based only on overwhelming evidence, then we're performing the very task that Apprendi and Alene instructs judges not to perform. And that same tension is noted in this court's opinion in Leggins. And in fact, Judge Richardson says, he takes solace in the fact that despite that tension, harmless error is a very narrow and a very demanding standard. So I do think that threshold for what it means to be uncontroverted is quite low.
Well, then why would the Leggins opinion have said in the proper way to perform harmless error analysis is to ask whether the proof of the missing element is overwhelming and uncontroverted?
It is a two-part test, Your Honor.
Yeah, it's conjunctive.
It is
It has to be overwhelming as well.
It has to be. Well, I think the government has to show that it's overwhelming. I think it's the government's burden to show, that the error was in fact harmless, and the government needs to show that the factual questions were both uncontroverted and supported by overwhelming evidence. Now, in our briefs, and as you and I just discussed, Judge Keenan, we do make the argument as to why we don't think the evidence is overwhelming here. But even setting that argument aside, even if we don't win on that, I think we still win on the first prong, and that's enough to say it's not uncontroverted. And Leggins is a great example of when the factual issues are uncontroverted, because in Leggins, the defendant said, I can't meet that element. Same as in Nader. I can't meet that element. I don't have facts. Here.
So where did you contest how long he was incarcerated or the date of his release, the time between the offenses?
Your Honor, I don't think that the defendant, in order to, survive an Apprendi error review, has to contest sort of element by element and offer proof for each element.
Sure it does. It's talking about evidence being uncontroverted and overwhelming, and we only know if evidence is overwhelming by analyzing the element that the evidence is meant to meet.
That's correct, Your Honor, but I think it would be enough for the defendant to say, I simply want to hold the government to its burden of proof. Right? I am not.
Right, but here it wasn't just, we went to a jury, the jury didn't get this instruction, so I didn't have to put on any evidence. Then you went to a judge who did have to decide it, and you had a whole hearing where he could put in evidence, and he didn't, and it seems to have been undisputed. So it's kind of different than the cases where you can just say, well, we didn't have to put in evidence in front of the jury on this.
Right.
This element had to be proved to the judge, and it was not contested there.
Sure. So two things to that, Your Honor. I would say, the first is that, the evidence that a defendant might put forward before a judge is going to be different than evidence he might put before a jury, just as a strategy in a bench trial might be different than a strategy in a jury trial. So I don't think looking at what...
This is all hypothetical and might totally be true in some cases, but in this case, is there a dispute? Do you disagree that he was in prison for the amount of time that the government says he was?
The length of his actual period spent in jail, Your Honor, I don't think is at issue, but I do think that...
What about the date of his release?
The date of his release, I don't think is at issue.
Because there was testimony from his probation officer.
Right.
Okay.
But, Your Honor, I do think that those issues, I think two things. One, his testimony or, his sort of offer of proof about the potential vacatur, really could impact those second two elements. Because, again, the government would have to prove that fewer than 15 years had passed between his release on his prior conviction and the commission of the instant offense. If the prior conviction has been vacated, I really don't think that there's a release on a prior conviction, could arguably be sort of a null point.
But again, you haven't contested that whether the prior conviction has been vacated is a question for the judge.
The first element, if the First Step Act or if the definition of serious drug felony required only the first element, then yes, that could be constitutionally decided by a judge. But I think in this situation, what the jury put below was, or what the government, per Department of Justice policy, requested on the jury form below was all three questions. And they sort of acknowledged the burden to prove those to a jury beyond a reasonable doubt.
But under Almendarez-Torres, is it an error for the judge to decide the first element?
If it were just the first element, I don't think that would be an error under Almendarez-Torres. No, I don't think fairly read that would be, Your Honor. But again, I think there were two other elements at issue. and the defendant indicated a desire to contest, to controvert, the government's assertion that that enhancement applied. I think even if Mr. Lee had stood up and offered, virtually nothing and had said, look, I demand to hold the government to its burden of proof. Now, a case that's potentially a helpful analog here is the Ninth Circuit's decision in United States versus Guerrero Yasso. And there, what the court said was, look, we have a defendant here. The defendant, signaled his intention not to accept the government's assertion that an enhancement applied. And he should have been given the opportunity to argue that before a jury. And what the judge said, if that had happened, he could have challenged the authenticity of certain documents. He could have cross-examined the government's witness. He could have pointed to chain of custody concerns with certain of the documents, right?
You also could have done all that in the hearing before the judge, right?
He could have done that before the judge here, Your Honor, yes. But I think that different evidentiary standards may have applied before a jury, and sort of different strategic considerations should have applied. So I think the minute that he controverted the evidence, with testimony, with his assertion, that arguably could have persuaded a jury to persuaded one juror to find reasonable doubt on those elements, I think that that's enough under this court's decision in Leggins. Otherwise, I think we're looking at an expansion of Leggins, which says not just uncontroverted, and supported by overwhelming evidence, but put aside the overwhelming evidence element for just one moment. Not just uncontroverted, but substantially uncontroverted, or convincingly uncontroverted, or sort of looking at the record to determine the degree of uncontrovertedness. And I think those are really questions about the nature and the degree of the evidence that go to the overwhelming prong, and not to the uncontroverted prong. And I don't think we can treat those two parts of that conjunctive test as synonyms of one another.
Thank you, counsel.
Thank you.
We'll hear from the government.
Thank you. Lucy Brown for the United States, and may it please the court. Harmless error from trial is a high bar, as well it should be, but if this case doesn't clear it, what does? And we agree with defense that these questions, the two narrow fact questions, should have gone to the jury in this case, and they didn't. But this error is harmless in this case for two separate reasons. First, the one we've been focusing on this morning, that there is overwhelming, and the government would argue uncontroverted, insufficiently controverted, certainly, evidence to support those two questions. And second, because the sentence in this case was driven by the guidelines rather than these enhanced statutory penalties at all. The Supreme Court told us in Netter that the question is actually this: is it clear beyond a reasonable doubt that a rational jury would have found the defendant guilty absent the error? And a way of showing that is this uncontested and overwhelming evidence. So let's look to what that was in this case. Here, as your honors have pointed out, these are just those two narrow questions. How long did Mr. Lee himself spend in custody, and when was he released in conjunction or in relation to the crime in the instant case? Those are undisputed at trial. There is a lot of evidence about them. There is the records themselves, the testimony of his probation officer, his video statements at the time of his arrest, but perhaps most importantly, his sworn testimony at trial when I asked him, you did about 5 years, right? Yes, I did. You were released at the end of 2015, right? Yes, I was. That's it. That's all we need to know on those elements. They were uncontested by his own sworn testimony, as well as all the other evidence that was introduced.
Won't these errors, for that reason, pretty much always be harmless? I mean, you can imagine a case maybe where it's a little unclear how long someone served because of, good time credits or something, and it's maybe the records are unclear, but should it give us pause that if we don't address the constitutional question, it may never be addressed because this will always be harmless?
I think there are a lot of ways that this can go and a lot of ways that they wouldn't be harmless. The facts just didn't line up in this case to make that happen. One immediate example that comes to mind is a case where a defendant would stipulate to the old chief stipulation where the issue of his prior conviction doesn't have to be proven to a jury. That would constrain the evidence that comes in at trial, and may limit the evidence that's before a jury on the record about this prior conviction in a way we were not constrained in this case because the defendant made us prove that to a jury. So more evidence came in this case than probably would in a typical case.
Still have the hearing in front of the judge.
Certainly.
But I guess, yeah, the defendant might have a little bit of a better argument that, well, we didn't get to put it in front of a jury. But it just, these are so, these two questions seem like they could be easily proven by documents, and struck me as probably always, except in an exceptional case, harmless, which means, you know, a judge might always get to decide them, even if constitutionally they shouldn't.
And I think these two questions are fairly routine. I think the district court said that in her order in this case. It is something that's proven by documents. Probably most of the work is done on that first question. Was there this conviction? And perhaps you have these sort of more robust disputes about that than we had in this case, and that's the protection. That's probably the most important thing to the defendant. It's probably a lot less about the time spent in custody and more about, was this a valid conviction? That's not what the dispute we had in this case, but one can certainly imagine that that is a robust argument. Here it simply wasn't, and I want to talk about that conviction as well. This defendant, it's not enough simply to say, this was vacated, don't ask me any questions, but it was vacated, take my word for it. That's not enough under the case law.
So how would you define uncontested? Because, I mean, Leggins does talk about overwhelming evidence and uncontested in the conjunctive. So you've got to show both, right? That it's overwhelming and that the missing element is uncontested. So if you were writing the opinion of the court, what would you say is the definition of uncontested that applies in the context of Leggins?
I think at the very least, there has to be something beyond the defendant's bald assertion, something. And that's a low bar.
We've got to, offer guidance here to the bar. And so how would you define uncontested? You're saying uncontested is something more than the defendant's statement?
Yes, Your Honor. I think even that low bar would eliminate the argument in this case because that was all he had.
But the defendant could offer more evidence. In other words, his statement, not in this case, but in another case, could be more comprehensive. So we don't want to limit the definition of uncontested to exclude anything the defendant says, do we?
So I don't think you want to limit it to exclude anything the defendant says necessarily, Your Honor. In this hypothetical, I think something beyond his mere statement that it was vacated, some sort of documentation, some sort of showing an offer of good faith, proof that something exists that could be obtained. It's why we have a hearing on this.
Okay, but doesn't that suggest it doesn't have to be overwhelming? You see what I'm saying? The two concepts are stated in the conjunctive, yet they do seem to run up against each other.
I think that overwhelming is my understanding of overwhelming is to the government's evidence about that prior conviction, and the uncontested is more about the defendant showing. And I think
that's not how Leggins sets it out. Leggins talks about the proper way to perform the harmless error analysis is to ask whether proof of the missing element is overwhelming and uncontroverted. That's why I'm trying to get you to help us perform this analysis by defining uncontroverted.
And I think perhaps I understand what Leggins is saying a little differently. My understanding is the overwhelming is on the government. We have to show this missing element was not even a close call. And I think we've done that in this case for the reasons we've been discussing. The uncontested, I think, has a little more to do with what defendant brings to the table. Did the defendant challenge it in a way that is sufficient to give this court pause that is this really a harmless error? Is there something to this? And I think at bottom, if you're asking for that hypothetical definition, I think it's fair to say it has to be something more than just a defendant's statement that this was vacated. And in this case, we actually also had indications that it was not vacated.
Well, is the term uncontroverted then surplusage in your view? In other words, if the evidence is overwhelming, does it matter? In other words, I mean, the court chose these words carefully, and it seems to me that we have to look at them as having distinct meanings.
Certainly, and I don't think it's surplusage. I think in any jury trial, the United States should and hopefully does believe their evidence is overwhelming, but certainly not guilty verdicts happen. I think it probably is a rare instance that this occurs, but it's supposed to be. It's an unusual and very specific fact pattern. I just think in this case, there was nowhere near a showing to controvert this evidence sufficiently. And in this case, we had just the defendant's bald assertion. We had indications that it was in fact not true, not just his admissions at trial, but the actual, on the issue of vacator that he raised for the first time after trial, there were indications that that was not true. For one thing, the evidence itself, the conviction, was obtained months after he said that it had been vacated. He said, I moved for this, I believe, in July 2020. It was granted in October 2020. This certified conviction was from January 2021. There's certainly no evidence of vacator on the face of the conviction. Also on the face of the conviction is a paragraph that talks about restrictions and penalties if expunged or vacated convictions are used adversely against people in a certain drug context. I believe it was marijuana convictions. But it says on the face of that conviction, you cannot use a vacated conviction against someone. That shows the seriousness with which this court takes that change in a conviction's history, and again, no indication. I also think it's important that the defendant arguably abandoned this argument at the trial level, because after this hearing, whereas Judge Rushing pointed out, this was his day in court. He had the opportunity, if he has this cross-examination, if he has these witnesses that he says now he could bring on remand, he had his day in court on this. This was a live issue at the district court level. There's no reason to hold that back if they exist. They simply don't exist.
You agree that even if the validity of the conviction was contested, the other two elements of the enhancement, the duration of incarceration and the recency, were not contested at all?
I do think they were not contested, yes. I think at the hearing, or excuse me, after the hearing, it's arguable whether the defendant even persisted in the vacator argument. I think he abandoned it, as did his counsel. When the when the pre-sentence report came out, it scored that conviction. It hurt the defendant. He had 3 points added toward his criminal history, increased his criminal history category, increased his sentencing exposure under the guidelines, and he filed pro se objections to that report, and his attorney filed objections to that report. Neither of them raised this issue. Neither of them objected to that New York conviction or its validity as a conviction. So I think arguably they even abandoned it after the hearing at the district court level.
I'll ask you the same question. So under the first element, was it improper for the judge to decide?
We certainly took the position, and we have conceded error in this case, that the two narrow fact questions should have gone to the jury. As far as that first question, did he have this conviction? No, I think under Almendarez-Torres, the judge properly decided that. There's also the separate issue in this case of a whole other reason why this is a harmless sentence, even if we have qualms about whether or not he controverted sufficiently, et cetera, which of course the government does not believe he did. This sentence was also harmless because it was driven by the guidelines. It was not driven by those enhanced penalties. And you can see that in the sentence itself. So in this case, the enhanced penalty for count 1 implicated a mandatory minimum of 180 months. The defendant got 280 months. The enhanced penalty for count 5 implicated a mandatory minimum sentence of 120 months. The defendant got 280 months, 160 months over that increased mandatory minimum. That shows the lack of effect that these enhanced penalties even had on the sentence.
We don't usually speculate about what a district court was thinking when it comes to the sentence, especially if the range mandatory minimum changed. Sometimes a district court will tell us on the record, I would apply the same sentence even without the enhancement. Do we have anything like that here?
We do, Your Honor. She did not say that at sentencing, but she did it, in fact. Counts 2, 3, and 4 had no mandatory minimum in this case, and the defendant received the same sentence on those counts as he did in counts 1 and 5 with those enhanced mandatory minimums.
Those ran concurrent, right?
They did, certainly, but we also saw in the 924C count. I mean, she certainly could have imposed 280 months on that because they're all running concurrently, and she didn't. She imposed the 60 months mandatory minimum. That might be one where we would have a more challenging conversation about the impact of the statutory range, but she didn't do that for counts 2, 3, and 4. She said 280 months is the correct sentence here, even when my hands are not tied by any mandatory minimum. For all these reasons, we think the error in this case in not sending those questions to the jury was harmless. And unless there are any more questions from the panel, we'd ask that you please affirm.
Thank you, counsel.
Thank you.
We'll hear from counsel on rebuttal.
Thank you, Your Honor. Your Honors, I think the government's language is telling as to how it looks at the Leggins conjunctive test. On multiple occasions, my colleague on the other side said insufficiently controverted or controverted sufficiently. That's not what Leggins says. Leggins doesn't say controverted sufficiently, controverted meaningfully. Those are certainly words it could have used, but it chose not.
Okay, so how do you define uncontroverted, Mr. Giles? Is it simply the defendant's bare assertion?
I think certainly defendants are acquitted on their bare assertions every day. I think defendants are acquitted on less than their bare assertions every day. I think defendants are acquitted based on their ability to poke holes in the government's theory, to hold the government to its burden of proof, to challenge, to cross-examine. Those are evidentiary tools that I think should be available before a jury.
Okay, but let me ask you, how can anybody prove, how could the government, in this case, the burden under Leggins, how could you prove both that the evidence is overwhelming and uncontroverted?
I think Leggins is a good example of that.
Where the defendant simply says the conviction was vacated, under your point of view, that's enough to defeat the Leggins test, right?
Yes, I do think that's enough under the Leggins test. I think it's enough for the defendant to say, I do not concede to the government's assertion that this enhancement should apply. I think it's enough to say I'm holding the government to its burden of proof. Now, Leggins is a good example of when a government can show both. When a defendant it does not controvert the evidence, concedes the evidence, okay, then the court proceeds to the second part of the Leggins test. Okay, he admitted it, but let's double check and make sure it's supported by overwhelming evidence.
Okay, so the basis for everything you're saying really is it's the government's burden, and so the defendant doesn't have any burden beyond contesting it.
That's right, Your Honor. And I think, one other thing the government mentioned is, okay, these facts are sort of easily proven by documents. I think that goes to the second prong, as much of the government's argument goes to the second prong, the overwhelming evidence prong. On the point of documents, I would point out that Shepard limits judicial fact-finding to judicial records. And a certificate of incarceration, I'm not certain qualifies as a judicial record. Certainly, it goes beyond, the sort of facts inherent in the conviction itself. So, yes, they may be easily proven by documents, and certainly the government is confident in its ability to argue this case in front of a jury. But again, I don't think the Sixth Amendment guarantees a right to a trial by jury on facts that are not easily provable by documents. Government meets its burden of proof on documents every day. I don't think that's a remarkable thing to point out here. The last thing I'll point out is, Your Honor asked Judge Rushing, wouldn't all this always be harmless under the government's theory? And I think that that's true. It would be a very rare case if a defendant had to, show uncontroverted to a certain degree, and it would be completely subsumed with the other prong of the Leggins test. Essentially, those two parts of a conjunctive test would become one. I don't think that's correct as a matter of plain meaning. I also don't think it's an appropriate way to read the court's precedents. I also think it begs the question, what is the harm in the Sixth Amendment context? If we're going to say that this was harmless from a Sixth Amendment, harmless, there was no harm, what is the Sixth Amendment harm? And I don't think the Sixth Amendment is in place because judges can't decide facts, judges always get facts wrong. So the harm in the Sixth Amendment context is not that a judge is going to reach the incorrect result. The harm is in who gets to decide it. As the Supreme Court says, the jury has to be a bulwark between the accused and the criminal justice system. So for those reasons, Your Honor, we would ask that you vacate the sentence. Thank you.
Thank you, counsel. We'll come down and greet counsel and then proceed with our next case. Next, we'll hear 19-1498, Selective Insurance versus Westfield Insurance. Counsel, whenever you're ready.
Thank you, Your Honor. May it please the court, Matt Abey of Nelson Mullins, here on behalf of Selective Insurance Company. Your Honors, before you is an insurance coverage action that arises out of a breach of contract action against a general contractor seeking to enforce a construction performance bond and demanding economic damages. There is no property damage that is, or legal relief for property damage that is sought in the underlying action. Today, I plan to address three main issues. One, the district court's application of North Carolina's comparison test was overbroad, forcing Selective to provide coverage to a stranger to the policy. Second, the district court compounded this error by refusing summary judgment on the unfair trade practices claim brought by the general contractor against Selective. And third, this court has jurisdiction over both claims. Given the court's, or for these reasons, Selective asks that the court reverse and remand with instructions that the claims against Selective be dismissed. I'd like to start where we must with the court's jurisdiction, especially given the court's order last Friday. The court does have jurisdiction, not here over a final order. We're not here under 1291. We are here under 1292A1. The parties have not disputed that the court has jurisdiction. I get that's not dispositive.
Did the district court order Selective to do anything while the case is pending?
While the underlying case is pending?
Yes, during this litigation, did the district court order Selective to do something while this case continues?
Yes, it required prospective defense of the general contractor in the underlying case.
Where is that?
So that is in the district, that is in the court's order. If I may, let me look first to, even the appellees agree and interpret the district court's order as requiring Selective, they use that word, requiring Selective to fulfill its defense obligations. That's in their brief at 22.
Right, I guess, you know, the court said Selective had forfeited the right to control the defense by not defending initially, and then said, you know, Selective was required to defend, and we're gonna, later in this litigation, we're gonna calculate how much Selective owes as damages because it didn't defend when it should have. And that's a little different than these cases where a court, as a matter of an injunction, says, I'm ordering this insurer to pay prospectively for the defense as going forward, and they can be held in contempt if they don't. It seemed to be different than what the district court was doing here.
Well, so we look to the practical effect of the court's order, and that's where we're getting that from the USA Gymnastics case, the Seventh Circuit. We're also getting that from Romero, which we cited in the brief, in the jurisdictional section of our brief. We don't necessarily look at the labels that the district court puts on it. We look at the practical effect. And here, the practical effect is the underlying case was ongoing. So by saying that Selective had a duty to defend, it had to step in, as the appellees claim, step in on a primary and non-contributory basis and take over the full defense. Now, the question that you raised about the forfeiture or the waiver of the right to object to certain monetary amounts or something like that in controlling the defense, that's a separate issue. The district court, though, said you have a duty of defense. And the practical effect of that is Selective has to step in and start defending that action.
Well, what is the status presently of the underlying action?
The underlying action has been dismissed, and that was dismissed after the appeal was filed and everything briefed.
So the duty to defend, how is the duty to defend issue that you brought up on appeal still before us when the underlying action has been dismissed?
Well, because at the time that we filed the appeal, we had that prospective
Right, but we have to
obligation.
have present jurisdiction. We have to have a live case in front of us on the duty to defend, don't we? Because that is the substance of your appeal.
That's correct, Your Honor. Although the underlying claims have been dismissed against the general contractor and some of the other parties, there are some other subcontractors that still have not resolved claims. So I think that the bankruptcy court entered an administrative closure of the case, but there still hasn't been dismissals with prejudice against all parties filed. So there still is
But with
technically.
regard to the parties before the court, you're saying what is still left? What I'm trying to understand is once the duty to defend is effectively out of the case, what do we have to decide here? In other words, if the action has been dismissed, it seems to me the issue of the duty to defend it's gone. There weren't damages assessed as a result of failure to timely defend. So, as Judge Rushing said, so we don't have that in front of us, the quantum of damages. So what's here?
Well, because the judge also ordered as a part of that duty of defense, you have backwards-looking duty of defense obligations, and that's just a monetary payment. But you also have the forward-looking. And at the time of the court's order, which would have been in April of 2019, there was still a duty of defense. And that case, as I said, the underlying case, although the majority of the claims have been dismissed, there is still a live controversy there and a duty of defense that's ongoing, including a payment obligation that is still there. So what we're asking the court to do is to rule that the court below erred in finding that there was a duty to defend. And that's still a live controversy that the court can resolve.
Why are you using, looking to Romero in the Third Circuit when we have a case in Lutz where they lay out what we're to look at to decide if it's final below?
Well, because we're not appealing this as a final order. So we're not appealing under 1291. The closest analog, I might say, would be that Penn America versus MAP case, which would have been 2008. But Penn American versus MAP doesn't apply here because that, again, was under 1291 and not 1292A1 as a mandatory injunction. And in MAP, there was already a defense that was being provided by the insurer. Here, we have denied coverage and did not provide a defense. And so the district court was forcing us into a position and forcing us to provide a defense to a stranger to the policy and enforcing that obligation brought by a even further stranger to the policy in the two insurers of that party, the general contractor claiming additional insured status. So we're even one more removed than MAP, and that's why under 1292 the court has jurisdiction. But if I may, judges, I want to turn to the duty of defense and why the district court got that wrong. The district court just applied an overbroad reading of the comparison test under North Carolina law. So as the court in the Court of Appeals of North Carolina in Cubitt has explained, the North Carolina Supreme Court changed the comparison test. It made a change of the law in the Harleysville versus Buzz Off case. Harleysville versus Buzz Off was a Lanham Act case. It dealt with whether or not there were some advertising injuries, and that fell under a CGL policy. And the Supreme Court was looking at whether or not the plaintiff was alleging that there was a violation or the advertisements were problematic because it was discussing its own product versus a competitor's product. And so the court looked at essentially the essence of the underlying claim. It didn't look at the labels that were applied. It didn't look at just the broad allegations in a sense that we would look to see just if we could find one little sliver of, in this case, property damage, and instead look to the essence, to the gravamen of the plaintiff's claim. And here, the gravamen of the plaintiff's claim was non-economic damages. They were suing to try and implicate Travelers' construction performance bond. That's what the damages were throughout the complaint.
What about the first supplemental complaint?
Well, I don't know that the court should have looked at the first supplemental complaint.
Can we review that court's decision to docket a supplemental complaint?
Well, it's not necessarily the docketing of supplemental complaint, it's the claims that were alleged. And the claims that were alleged were for non-economic damages. The supplemental complaint, even if the court did look at it, really just said that we need some more investigation. These are some issues that we need to look into and figure out if they need to be corrected in
Did you
order.
object though, to the district court's consideration of the supplemental complaint?
Well, we said that the district court didn't need to look at the supplemental complaint, that the operative complaint was the first amended complaint.
Right, but did you ever tell the district court that it couldn't do that it would be error to do that?
I don't know that we said that it would be error to do that, but we did say that the court should look to the operative complaint, which is the first amended complaint. But Judge Keenan, even if you look at that supplemental complaint, it doesn't change the allegations. It doesn't change the claims that are brought. The complaint was asserting a claim for breach of contract. And the breach of contract claim was essentially to look for economic damages related to the quality of the work. There's no property damage that results from the quality of the work. The two allegations that the appellees want to rely on are in paragraph 150L and then 150E. When you talk about materially and substantively breaching the construction contract by, among other things, failing to properly construct the project buildings in a manner preventing water intrusion, which is causing damage, and the potential for significant mold problems in the residential units as well as the common areas. That allegation, though, again, is under the breach of contract claim. And when one thing that we agree with, for my colleagues on the other side in their brief on page 26, is that we have to review the complaint in context. Well, the context of that allegation is about water intrusion caused by the building envelope, not water intrusion caused by any plumbing issues. And again, because we have an AI endorsement here, we have to look to plumbing allegations, not to allegations that there were water intrusion from some other subcontractor or some other issue that was out there.
What about the allegations about waste plumbing deficiencies?
Yes, so that is in Barber's expert report and the catalog of issues that's in the supplemental complaint. But again, it says that those need to be investigated and corrected. It does not talk about that there are damages to the property, and we need economic or we need legal damages to compensate for that property
North
damage.
Carolina just required that the insurer's on notice that the work, that your insured's work is at issue and is causing damage?
I don't think so, not after Harleysville. Not after the Supreme Court's opinion in Harleysville versus Buzz Off. I think it's narrowed the test, and it looks to the gravamen of the complaint.
What do you think Harleysville did other than maybe get rid of mere possibility? They didn't mention mere possibility, but do you think they did something bigger than that?
I do. And I think that you look to the essence of the claim. You look to the gravamen of the complaint.
Where do they say that?
They said that they cite in the waste management case, I believe it was at 64. Your Honor, if you'll give me a second, I can get you a page. It was at page 7 of the North Carolina Reporter, on page 611 of the Southeast Second Reporter. And Judge, in that section, it talks about looking to stripping the complaint. The quote is, "We now strip to its essentials the amended complaint to ascertain the gravamen of the plaintiff's claim." So we're not looking to whether or not we can isolate one particular line about we may need to investigate future issues. We look to the essence of the claim, and the essence of the claim here is for economic damages. The general contractor was trying to implicate, or the developer was trying to implicate the general contractor's performance bond, and they were trying to seek economic damages from that. Judges, we did also raise the summary judgment issue. The court erred in refusing summary judgment on the unfair trade practices claim. That's intertwined with our claim that there's no coverage here. I'd rest on our brief for that argument unless the court has any questions. But based on the issue that the trial court applied an overbroad reading of North Carolina's comparison test, we'd ask that the court reverse.
We'll hear from the appellees.
Good morning, Your Honors. Morgan Templeton on behalf of the insurer Appalese. I'd like to first start off with the merit side, and then I'll address the procedural issue on the back end. The court should affirm the district court in all respects. It is clear that Weaver Cook was an additional insured on the selective policy that was issued to DD Plumbings. And as Judge Rushing pointed out, there's implications in the amended complaint that the raw sewage was entering that building through the plumbing and affecting the interior trim of the building. That is property damage that is caused by an occurrence and is covered under a CGL policy. The underlying complaint is far more than a breach of contract claim. It is a negligence claim, a construction defect claim surrounding the water intrusion allegations at the building. It is clear that North Carolina law treats the duty to defend separately from the duty to indemnify. The duty to defend is a much broader concept, and all questions go to the favor of the insured. They do not go to the favor of the insurer. The seminal debate that I think Selective is advancing to this court is an interpretation between the waste management case, the buzz-off case, and tangentially the Cubitt case that followed about a year after the buzz-off case. Nowhere in those opinions, in the subsequent two opinions, is waste management overruled, vacated, or otherwise noted as restricting the interpretation of the duty to defend. It is broad. It is intended to be broad for the benefit of the policyholder. I would direct the court to the language in waste management which says, quote, where the insurer knows or could reasonably ascertain facts that if proven would be covered by the policy, the duty to defend is not dismissed because the facts alleged in the third-party complaint appear to be outside the coverage or within a policy exception to coverage, end quote, and that's at page 377 of the opinion. That very language is subsequently cited in the Cubitt case. So the Intermediate Court of Appeals in North Carolina clearly thinks that waste management is still good law, and we submit that it is. Of course, the lower court went to great lengths to discuss the property damage and to find that there was coverage and a duty to defend. And to address Judge Keenan's question, the case is not moot. Both Westfield and Zurich sought retrospective damages, and they also sought prospective damages. And from the date of the district court's order in April of 2019, there was an ongoing duty to defend throughout the life of that case.
Right, but damages haven't been assessed. I wasn't suggesting that it was moot, but I'm just saying that there is nothing substantive in this, perhaps nothing substantive in this appeal for us to grapple with because an assessment of damages has not been made.
Yes and no, Your Honor.
Okay.
As far as the insurer appellees, within the motion for summary judgment, there were affidavits submitted setting forth both what Zurich incurred and what Westfield incurred as retrospective damages. And the motion itself sought that relief, and the motion for summary judgment filed by the insurer appellees was granted in all parts. So I would submit that there was a finding of damages in addressing that issue. And then also I would point what Judge Rushing raised.
But you're saying, excuse me, I didn't mean to interrupt, but I want to make sure I understand. So you're saying that the court ordered a specific amount of damages? Because I didn't see that.
I don't think that the court listed out the monetary numbers that were contained in the motion for summary judgment, but the order of the court at the end specifically said the motion is granted, and the evidence was there. So if this court sent it affirmed and went back, it's just merely asking the district court, here's the, you granted it, here's the damages that were uncontested, and then discussing whatever.
Okay, but we're here on the interlocutory order of whether there was a duty to defend.
Sure.
Not the court's assessment of any or determination of damages owed, right?
Certainly. That is correct. And then the point I wanted to address with Judge Rushing on the prospective relief, which sort of dovetails into the 1292 analysis, within that same memorandum of support, which I think you'll find at docket entry 71, which was the memorandum in support. In that paper, they specifically sought relief for the duty to defend ongoing. And so again, that was.
But the court didn't order that. I take your point that the court said it granted your motion and didn't parse it, but the court didn't also say, and I'm ordering Selective to begin defending this and pay, forward looking. The court actually entered an order staying the damages question.
Only as to, as I read the order, it stays the action as it relates to damages that were being brought separate and apart by Weaver Cook, which brought the unfair trade practice claim and their bad faith claims, which the court was not going to address.
Selective, just as a factual matter, did Selective take over the defense and start paying out?
Your Honor, they did not, which I suspect would be something.
Could you have moved for contempt, or would you have needed an additional order from the district court?
So walking you through the timeline on that, April of 19, the order is entered. Within 28 days or 29 days after the appeal was filed. And rightly or wrongly, out of deference to this court, once the appeal was filed and the district court said it was stayed, I felt it would have been inappropriate to do something below.
Yeah, I don't want to I'm not calling into question your judgment. I'm just wondering, there are cases where this has been, an order has been injunctive, and so an appeal could be taken, but those all read very differently. They have the court actually ordering, as of this date, the insurer must begin, under threat of contempt to pay. And that, I was just curious if that seemed to be the understanding of the parties here or not.
Certainly, there's no language in there talking about the threat of contempt or anything like that. I certainly concede that point. Switching gears quickly to the duty to defend and this notion that the pleading itself was somehow deficient. I would point the court to that pleading was filed with permission of the court. It was accepted by the court. Selective could have come in and defended that action at some point and moved to dismiss the complaint if they thought it was defective under Rule 7. They didn't. They could have come in and moved for a 12b-6. But that, to me, even if you accept it as the premise that they should have done something, they didn't. And they had notice of that George Barber report and the allegations that were being made as to the raw sewage. And if we look to Waste Management, if they know, which they admit they received the tender letter, they admit they received the pleading, they're on notice at that point. And if we look to the quote that I read to your honors moments ago, if they know of this information, they're duty bound to step in and defend. Insurance companies defend frivolous, fraudulent claims all day long. And that's a low bar, and that's the whole purpose, come in and defend. Lastly, and I know I'm running out of time, I do want to say the practical effect of this order, in our view, it was tantamount to a complete and final decision as it relates to the duty to defend. These parties have been in litigation for many, many years, and don't think there's anything more for the district court to do vis-a-vis the merits of the duty to defend. And we think, as I've explained, I believe that it is triggered. I recognize it's de novo review, but at least two judges below have weighed in various orders saying that they view it as having an allegation of property damage caused by the occurrence, and these folks should have defended. With that said, I'm happy to answer any other questions the court may have. Thank you. We would ask that you affirm in all respects. Thank you.
Good morning, Your Honors. Mike Medford from Raleigh, North Carolina for the Applee Weaver Cook Construction. The court's already heard a lot about the issues on both sides of this, and I'm not going to take up the court's time with a whole lot of extra stuff. I would note that to the extent that Selective argues that the Buzzoff case, also called the Harleysville case, changed the law in North Carolina, the Cubic case, it's also cited by Selective, talks about, it changes it, but then later in the opinion it said it didn't change the part of Waste Management that talks about the scope of materials that should be considered in determining the duty to defend. Since the Harleysville buzz-off case, the appellate courts in North Carolina and the federal district courts in North Carolina, in cases cited in our brief, have continued to apply the broad North Carolina rule about what you look to. And the North Carolina Court of Appeals in NC Farm Bureau Mutual Insurance Company versus Cox, 823 Southeast 2nd, 613, 625, 2019, which is, I think, 9 years after the Harleysville case. It's cited at page 27 of our brief, said, although our Supreme Court has used the word complaint in Harleysville, the court clearly did not intend to limit our review to the actual, in this case, third-party complaint, and thereby overrule plenary precedent. In Harleysville, it appears that complaint was used to mean the factual basis supporting the relevant third-party claims, i.e. the pleadings, depositions, answers to interrogatories, and other documents that were properly before the trial court on summary judgment. So, and there are plenty of references in the cases that say, well, if it's not clearly alleged, if it's not alleged in the complaint, then the insurer doesn't have a duty to defend unless it has knowledge from other sources. Well, in this case, by the time this matter was before the district court on the coverage issue, it was in the complaint because it was there by way of the supplemental complaint, which clearly alleged property damage. And even though Selective says, well, the court in the underlying case should not have allowed a supplemental complaint, the fact is that it did, and that was the place, if you're going to challenge that, to challenge it not by collateral attack in this case, but in that case. It was a pleading that was before the court. It was a pleading that reflected property damage, and there were other discovery materials before the district court that reflected property damage. All that was properly considered under the North Carolina rule. And so there was really no good basis for contending that there was not coverage. The district court did stay all proceedings on damages, reserved for later decision. That issue, once this court is finished with the case, however it determines the jurisdictional issue, it'll go back to the district court for determination of that. Selective, however it interprets Judge Britt's ruling in terms of its prospective duty to defend, it did not defend. And so that will be an issue before Judge Britt when we go back. And we will seek to recover both our retrospective defense costs plus defense costs that are now retrospective but that were prospective at the time Judge Britt made his ruling. Counsel did not argue the issue about our attorney's fees and the rates charged. So unless the court has questions about that, I'll rely on what we said in our brief. Counsel also did not argue about the unfair trade practice claim. That's based on the fact that Selective clearly failed to respond to the tender that they admit receiving for a year, approximately a year, and they finally did it when we submitted when our client submitted a counterclaim for coverage under the additional insured provision, and finally they came in and said, well, we don't have coverage. But it took them a year to do that. The North Carolina law is clear. Unfair trade practice, unfair claims practice statute is clear that they had a duty to promptly notify our client of what their position was on that tender. Whether we agree with it or not, we were entitled to know what it was. It took over a year to do that. As there's no North Carolina case on this, but we cited 2 New York cases in the brief that said one of the reasons for the requirement of prompt notice by the insurance carrier is so that the insured can determine, plan their defense, plan what they're going to do, plan for their protection. If they don't know what position the insurance company is going to take, then they're deprived of that. And that, in the New York cases, they held delays as short as, I think it was 42 days as being unfair trade practice or violation of the statute.
He's saying that is inextricably intertwined. What's your position on that?
It's not. The claims are different. To determine the duty to defend, it is necessary to look to what the allegations were and whether there were claims that could be interpreted as property damage claims. On the unfair trade practice claim, The claim is the length of the delay by the carrier in stating their position and explaining their position. Those are two completely different issues. Regardless of the outcome of the duty to defend issue, we have a claim for unfair trade practice for the delay in providing notice of what their position was. In the Rux versus Republic of Sudan case, the Fourth Circuit said, if we don't need to decide it in order to decide the appealable issue, or if it's not inextricably intertwined, as it isn't here, then we don't take up the other issue. We just take up the one that's appealed. In the Church Mutual Insurance Company case, which is a 10th Circuit case, 657 Federal Appendix 747, which is one of the cases dealing with whether an order for duty of defense is appealable. The court in that case, because there was an order directing them to pay ongoing defense costs, held that issue was appealable, but held that the bad faith claim that was also asserted was not inextricably intertwined with the duty to defend and therefore was not appealable. And that's a 10th Circuit case, Your Honor. So short answer is we don't think it's intertwined. It's two different issues. And we think regardless of what this court decides on jurisdiction as to duty to defend, that issue is not properly before the court. If it is properly before the court, the evidence is clear that there was a year's delay in the face of a North Carolina statute that requires prompt notice of the insurance company's position and a clear explanation of the basis for their decision. That was not met. The Judge Britt, we think, could have decided as a matter of law that that was an unfair trade practice. He said, well, I think there's an issue of fact to go to the jury about whether that's too long. Since we don't think that's appealable, we have not raised it in front of the court, but we think it's clearly not something that was reversible error. It was the right decision. If nothing, we think it was too generous to select it, but that issue is for another day. Or if this court reaches it, that's why it should affirm. On the issue of the overall jurisdiction on duty to defend, we did not oppose jurisdiction in the brief. We understand that's not binding on the court. Jurisdiction is jurisdictional. But we would love for this court to decide the case on the merits. So we go back and all we have to do is resolve damages before Judge Britt. My client's been out of pocket for a long time on the fees that it's spent on this case. We'd love to get it decided. We understand the court's concern. The judge clearly found that there was a duty to defend. I think he would have anticipated that Selective would then come in and actually provide a defense, which it did not. He did not use the magic words that are in some of the cases. We'll rely on the court to determine how that affects your jurisdiction. I'll be happy to answer any questions that the court has.
Thank you, counsel.
Thank you.
We'll hear from counsel on rebuttal.
Thank you, Your Honors. A couple of points here. My colleague on the other side mentioned a negligence claim. There is no negligence claim involving the general contractor. I'm looking at Joint Appendix 350, the third claim for relief, which is negligence. That's against other defendants. The only cause of action that will be implicated here and that they rely on is the breach of contract action. And that's not the same as a negligence action that is raising property damage. There was also a claim about whether or not we could have opposed the supplemental complaint. Selective was not a party to that litigation, so no 12b6 would have been possible for it to raise in the underlying case. My colleague on the other side also talked about the scope of the information available to the insurer when you're looking at the duty of defense. I don't think the court necessarily has to wrestle with the scope in order to get to a reversal here. And the reason for that is you're looking, again, post-Harleysville, you're looking at the gravamen of the claim. You're looking at the essence of the claim. You're stripping it from everything else, and you're looking at what is the thrust of the claim that they are claiming implicates coverage. And here, the thrust of the claim is economic damages implicating the performance
But
bond.
surely the gravamen of the claim doesn't mean we ignore the particulars, right? There may be one overarching theory, but if one of the particulars implicates the plumbing, then we would have to consider that, right?
But an implication alone is not enough. Again, you're looking at the damages sought were for economic damages, were for repairing and replacing. For example, the supplemental complaint talks of the catalog of issues that may warrant additional factual pleading. It then says that the cause of the discharge, which you pointed out earlier, Judge Rushing, should be investigated and corrected. Well, that corrected isn't a talk about the property damage. It's investigating, figuring out, and bringing it back up to the quality that they anticipated, which again implicates the performance bond. It's not implicating the CGL policy. And one of the cases that we cited in our brief was Hartford versus Gelshanen. That was a case involving North Carolina attorneys that were sending out mailers to individuals involved in accidents in North Carolina. And the class action implicated a Privacy Act claim. There was also a North Carolina common law privacy that the same set of facts could have alleged. It could have alleged either a statutory claim or a common law claim. And the court there, which was the Western District of North Carolina in 2019, said that I hear you that the facts may have fallen under statutory or common law, but they didn't assert the common law claim, the covered common law claim. They asserted the statutory uncovered claim. And that's the same thing here. The assertion here was for economic damages on the performance bond, the problems with the PT cable tension systems, the building envelope, the fact that they didn't complete construction on time. That is the gravamen of this claim, and that doesn't implicate the duty of defense. Insurance, as the North Carolina Supreme Court in 1991 said, that insurance policies aren't performance bonds. They're covering a different type of risk. And the fact that Weaver Cook could they have pled into coverage? Absolutely. Weaver Cook most certainly, or the developer against Weaver Cook, could have pled a general negligence claim, a general construction defect claim, and we wouldn't be here today. They didn't. They instead pleaded in order to get to that performance bond because perhaps that's what they thought was the quickest avenue to get the project back on track. But that's a different case. So, judges, I would just end with that implications aren't enough. There was no property damage claim that was made here. There was no damages for property damage that was sought from an occurrence in this case. It's simply an economic damages claim, and therefore the court should reverse. Happy to answer any other questions the court may have.
Thank you. We'll come down and greet counsel and proceed to the next case. All right, we'll proceed with our last case, 22-4284, United States versus Mitchell. Counsel, whenever you're ready.
Thank you, Your Honor. May it please the court, I'm Andy DeSimone, and I represent Mr. Mitchell. I want to spend my limited time this morning, or I think it's the morning, on the erroneous application of the assault enhancement. Under the plain text of that enhancement, The government had to prove that Mr. Mitchell assaulted an officer, that he knew the person he assaulted was an officer, and that the assault itself created a substantial risk of serious bodily injury. I'm going to focus on 3 of the district court's errors as to the assault enhancement. First, the district court applied the wrong legal test. Second, the government failed to prove that any assault created a substantial risk of serious bodily injury. And third, the government failed to prove that there was an assault in the first place. So first, the district court incorrectly focused on Mr. Mitchell's overall conduct in creating a dangerous situation rather than on the more narrow question of whether he committed an assault that in turn created a substantial risk of serious bodily injury, meaning a considerable or important risk of injury involving extreme pain, protracted impairment of a bodily member, or requiring surgery or hospitalization. So here the court said, quote, the exigent circumstances, the emergency that was going on there, the danger to all involved, the public and law enforcement is at its highest level with him. That's JA 22. The court continued, I mean, there were a half dozen police officers there. There's a car operating with an intoxicated, addicted person with a firearm who's a felon in the middle of the street. That's the scene you create for all these national disasters. The court continued, this is his fault, JA 23. These were the conditions that he created, JA 25. The officers don't know whether they're going to get killed right then and there. That's JA 24. And he shouldn't profit from the fact that the officers diffused the situation. That's 25. And when he actually overruled the objection, the court said, defendant's behavior and conduct created a substantial risk of serious bodily injury, not that a supposed assault created that substantial risk. So we don't dispute that Mr. Mitchell created a dangerous situation by passing out at the wheel with a gun in his hand. But that is just not the question under the plain text of the assault enhancement. The court had to decide the much more narrow question. We're also not saying the district court could never consider those circumstances, right? But the proper time and place to consider them was under 3553A, after it had already calculated the guidelines, not when deciding whether the assault enhancement even applied. But in addition to that legal error, the government just did not prove that it was more likely than not that any assault created a substantial risk of serious bodily injury. So even if we assume for a second that there was an assault with the strike to the officer's face, there just was no serious risk of serious bodily injury from that assault. Remember, Mr. Mitchell was sitting down in a car with limited range of motion. He was surrounded by 8 officers. He was just being roused from unconsciousness when he flailed his arms. And then you can look at the reaction of the officer.
Didn't he actually strike him numerous times?
Well, the PSR says that there were 2 strikes to the face and a couple to the arm. The officer, when he testifies on J37, testifies there was 1 strike to the face. You know, we objected to the PSR, and then there was the testimony. But I think, you know, that goes to sort of the assault question.
This is a question of fact, right? And we reviewed that for clear error?
Correct, correct. But if you look after the strike, the officer continued to try to pull Mr. Mitchell out of the car. He did not cry out or cover his face. And importantly here, there was
He did cover his face. He says, I covered my face and he kept hitting my arm, right?
I think that's correct, yeah. I don't remember the cover
He hit him
face.
once or twice. I think the record in front of us says twice. Hit him twice in the head. The officer covers his head with his arm. Mr. Mitchell keeps hitting his arm and finally has to be tased.
Well, the thing is, the assault itself only happens over the course of about 2 seconds. This is at the 4-minute mark of the video, right? At that point, the officer says on JA38, he clasps his hands on the wheel. And so that's the remainder of the situation. He's not striking the officers. His hands are...
Mr. DeSimone,
Yes.
I don't mean to interrupt your discussion of the facts, but it seems to me you've left out something that you addressed in your brief, and I'm wondering whether you're abandoning that or not. In your brief, you talk about the district court's, the perceived procedural error of the district court's failure to explain its decision, its failure to make the necessary findings, its reasoning And are you abandoning that now
Absolutely.
and just arguing clear error? Because there's a different standard of review that
Sure.
applies to the procedural error than the clear error on the factual resolution of the actual assault itself. So could you clarify that for us?
Yes, Your Honor. Of course, we're not abandoning that area. I think at baseline, this case would have to go back for resentencing, especially under United States versus Bolden, especially as to the second. You cannot even look to the PSR to find a finding of facilitation, and the district court certainly didn't make one. And it's unclear how there could be facilitation. So I do think it, at baseline, has to go back for resentencing. All we're saying is that, at resentencing, the government can't supplement the evidentiary record under United States versus Parker from 1994. So that we're stuck with the facts as they are. And so my argument to you is that on these facts, there was not evidence of a substantial risk of serious bodily injury or even an assault. So I do think you do have to reach that question because it's sort of a higher level of relief that we're asking for. We're asking for remand for resentencing without the enhancements. But I hope that addressed your question.
Well, I guess what I'm saying, though, is don't we have to look? If we find that the district court did not adequately explain its reasoning, then we can only affirm if the record compels the conclusion that the requirements were satisfied. Isn't that correct?
Yeah, and I guess what I'm saying is that the record does the opposite of that. The record compels the opposite conclusion, that there was no assault and that there was no substantial risk of serious bodily injury. The officer was not hurt at all. It's not in the PSR, it's not in the testimony, it's not in the video. That's a standard way of the government showing, a substantial risk.
But I thought the standard is a potential risk, not that he necessarily had to be hurt. It's the potential for serious bodily injury.
I think the word potential is a little dangerous because it's a substantial risk. It's not a potential just would mean any risk. But we're not, the plain text of this enhancement talks about a substantial risk of serious bodily injury. So a substantial, just from a dictionary definition would mean considerable or important. And here you've got someone who's sitting down, who is in a car, who's surrounded by 8 officers, who has a limited range of motion, who's just being roused from unconsciousness. So the potential, I think we have to go, it's actually more than that. Was there a considerable risk that he would do such a high level of injury to the officer?
Do you think the facts that you just laid out distinguish this from Alexander in the Seventh Circuit?
I think absolutely, right? There
the officer was hit a couple times in the head and like here, and that was it.
Yeah, so there, a couple things. The defendant was fully conscious, right? The defendant was standing up, was right in front of the officer, and it was a single officer, right? Not 8. So the defendant had full range of motion, standing right in front of the officer, squared up, and unleashed a right hook, hitting the officer's head, and then he tries to hit the officer's head again with a left hook. So he was obviously trying to hurt the officer, and he did hurt the officer, right? The officer suffered a sore neck and scraped knees. Not in themselves serious bodily injury, but you usually have some injury from which you then infer that there was the intent or the...
You're saying the court should look at all the facts and circumstances, and aside from that, not just these few seconds, look at the totality.
No, because
But you're asking us to disagree with the district court on this fact about whether he was intending to hurt him. And in the Seventh Circuit, we can say he was intending, but here we can't.
Well, I do think it's important to look at the plain text. I mean, this is a textual argument because the plain text of the guideline talks about that the assault itself has to create the substantial risk of serious bodily injury. And so the assault itself, and this is from the PSR on describing the offense, and that's 81 to 82 of the JA, and 94 where the probation officer responds. The assault itself is identified as the strike or strikes to the face. And And so it's that couple of seconds that really matters. Does that couple of seconds, in the circumstances which existed at that time, did that create a substantial risk? And I do want to back up a little bit to the supposed assault, because there does have to be an intentional strike, not a reflexive strike. And he had to know it was an officer. So here it happens right around the 4-minute mark of the video. If you look just in those couple seconds, at that time, the officers were rousing Mr. Mitchell from unconsciousness, and one of them even said, quote, "Keep in mind he's incoherent, keep in mind," end quote. That's a very important fact, because it's the on-the-scene contemporaneous understanding of an officer who's in the thick of it. Also, at the time of the strike, the officers had only announced they were police one time, right? It was only after the strike, after that 4-minute
Did the
mark.
district court note all the blue lights, that there was a police cruiser parked in front where Mr. Mitchell could see it and the blue lights were activated?
That's absolutely right. And there were uniforms, right? But uniforms and flashing lights mean nothing to an unconscious person. And he was unconscious until...
But when they pulled him out of the car, he said, "What did I do?" Well, he didn't say that, but
The first thing he said was, what's going on? And then he says, what did I do? So, I mean, that's 50 seconds later, and it's still, the first thing he says is, what's going on? Like, he still doesn't really know what's going on. It was not prolonged. Again, this is just a couple seconds, because, again, after it, on J38, the officer says he clasps his hands.
Hey, counsel, let me interrupt you because you've got fewer than 10 seconds. Are you addressing the 4-level enhancement at all?
If you could give me
Resting on your brief, I guess, on that.
a second, I would have 2 points to make about it, but I can save that for rebuttal or do it now.
You can make your points.
Okay, thank you. So I think it's really to juxtapose Jenkins, right? Because Jenkins, you've got a report of someone firing a weapon in downtown Charleston, South Carolina, a city. And then the police go down there, they find the person who matches the description. The person has a gun in one hand, cocaine in the other, and wrestles with the officers. Again, this case is totally different. We talked about how he was unconscious, a gun in his hand, cocaine in his pocket. This is out in the country in a rural area.
I was going to ask that. So in Jenkins and then also in Bolden, on the facilitation issue, there is this question of the environment or the atmosphere.
Yeah.
Does that make a difference?
Yeah, I mean, to me, it's a completely different atmosphere here, right? No suggestion that he could be emboldened or like to protect it from no one. There was nobody around. Like,
I thought his attorney in the district court said he needed a gun for protection in Kinston at night.
That was for his job as a truck driver. Yeah.
So why wouldn't he also need it for protection as a man with 3 grams of cocaine in his pocket?
I mean, I think that's a separate question, right? That's the separate question of whether it facilitated, or did it just have to do with his job as a truck driver? I think the problem here for practitioners, right, just practically, is if it's affirmed here, practitioners will have very little guidance as to when it should and when it should not apply, because...
What did the district court say about this 4-level enhancement?
Very, very little. All he says is that the facts support something like it was supported.
It made a conclusion.
Yeah, just a conclusion. We don't know his thinking, which I guess goes to the error under Bolden, right? So I think it would have to go back for the district court, if this court doesn't find, that if finds sufficient potential evidence, they would have to go back so that this court has something to review.
Thank you.
Thank you.
We'll hear from the government.
May it please the court. The district court's ruling in this case was based on a lengthy hearing and developed factual record. So those findings of facts were not clearly erroneous. I'd like to also start with the assault. First, the court did find that the defendant's behavior and conduct created a substantial risk of serious bodily injury here. And I want to be specific about what that behavior and conduct was. Specifically, directing the court to page 37 and 38 of the record, the officer who was actually struck in the face testified and was subject to cross-examination during the hearing. And what he testified to is that he was struck in the face while he was in the vehicle. And he also clarified that he basically had his upper body in the vehicle, that he was struck in the face, and he actually fell forward and hit his face, and then had to throw his arm up in order to protect himself and was struck again multiple times in his arm. So under those circumstances, I would also point out to the court that he indicated that he had told multiple times, he said in his testimony, that he was saying police, that the defendant stared at him, and then that's when the assault occurred. So I think
Let me ask the question regarding the procedural sufficiency. This is what, frankly, is troubling me in this case. I mean, there's definitely evidence of the assault, but we don't have any, it seems to me, any explanation by the district court on what it relied in order to reach its conclusions. And I'll be asking you that again with regard to the 4-level enhancement, which I think is totally devoid of any explanation. But even with regard to the assault, we don't really have any idea of what the district court was relying on. Wasn't he essentially just stating his conclusion? And it seems to me that then maybe you have a problem under our case law, like Wilkerson, that says that we can't even get to the issue of substantive reasonableness before we know exactly what the district court was talking about in reaching the conclusion. So how do we get there in this case, to your position?
Thank you, Your Honor. So I would point out the court did make a ruling here on page 53 of the record. The court also adopted the findings of the pre-sentence report, which found that the officer was struck in the face by the defendant, that it was an assault, and that the enhancement should apply. I would also point out that the court had a really developed factual record in this case, which I think distinguishes it from some of the other cases, and particularly the Bolden case that was cited and I know that goes to the other issue, but cited by opposing counsel. The court heard testimony from 2 witnesses who were at the scene. The court had the video in front of it. And I would also just to point out, the court did a lot of questioning of those witnesses during the hearing itself. It was clear that the court was clued into what the issues were. They were laid out by the parties during the hearing and in the objections. And the court clearly took interest in that and asked questions that were pertinent to those issues that were raised. So, what the court had before was an officer testifying that he said police, the defendant stared at him and then punched him in the face, and then continued to try to assault him, punch him, and struggle with him as they tried to pull him out of the vehicle. And there was, again, significant evidence that the defendant knew that it was a law enforcement officer. There were flashing lights clearly in his frame of view. You can see that in the video. The officers also testified to it. There were a number of officers on scene. You can hear them yelling police several times throughout the video. And they were in uniform. This is not a situation where we have...
What about this issue that he was incoherent?
Your Honor, I think here there was testimony that he looked directly at the police officer and then punched him in the face. And the standard here is clearly erroneous. So the court, in determining that the enhancement applied, made that finding that it was a knowing assault, that he knew he was striking a police officer. And that was based on, again, a very developed factual record. And as to the sort of third element of this, which is the substantial risk of serious bodily injury, the testimony was that there was a punch to the face, that the officer actually fell forward and hit himself a little bit. There was no testimony as to injury, but injury is not a requirement. It's a substantial risk of serious bodily injury. We don't have to actually show that there was an injury. And a punch to the face, as the Seventh Circuit noted in Alexander, even one blow to the face could be enough to create that substantial risk of serious bodily injury. Obviously, the head contains the brain, eyes, lots of vital organs, and so a serious punch to the face could create that substantial risk. And I would also point this court to its unpublished decisions in Mile and Cooper, which also deal with cases where somebody punched an officer and this court upheld the application of that enhancement. I'll move then to the facilitation, unless the court has any more questions on the assault. The standard is that the firearm facilitated or had the potential to facilitate another felony offense, in this case, possession of cocaine. I would just point the court to the full factual record here, which was that the firearm was stolen, loaded, in the defendant's hand, sitting on his lap.
But what about the connection to the cocaine? Where's the evidence of connection to the cocaine? And see, that's just what's bothering me, maybe about the district court's failing to explain anything, because maybe there was a connection, but it seems to me you've got mere proximity in this case and nothing more.
I think there is more than proximity here again, and I think the fact that the firearm is stolen and loaded, the fact that it's late at night, it's on a rural road, as defense counsel in the sentencing pointed out, Kinston at night, that was his explanation for why the defendant had a firearm on him. So it stands to reason that having a firearm could be necessary to facilitate.
That's just total speculation, though, isn't it? I mean, and again, this goes to why couldn't the district court have told us what constituted the connection? Maybe it's what you say, but do we have to? The case law says we've got to find that the evidence compels the conclusion in order to uphold the district court in absence of any explanation from the district court. And here there's no explanation. There's simply a recitation of a conclusion. And so how does the record compel the conclusion that he was using the firearm in connection with the cocaine, which was in his pocket, and he was unconscious, slumped over the wheel?
I think as this court has noted, firearms and guns, when they go together, there's sort of an inference that they're connected. And that is not just in the context where there is drug trafficking evidence, but also in the context where they're possessed together. And I think, again, the full range of circumstances
That's
here.
not always the case, right? It's often when say there's a warrant to search a home and the police find a gun and they find drugs, if those aren't in the same location or there's not some reason to think they go together, we've sometimes said that's not enough. In the cases where there's drugs and a gun on the same person going into the public sphere, we've said in numerous cases that it's you can infer a connection there because someone would take a gun with them to embolden them or protect their drugs in public. And we've said that in Woods, unpublished, and in Jenkins, the published case, et cetera. But there's a distinction in what kind of proximity and when proximity matters, isn't there?
I agree, Your Honor. But I think here there's definitely proximity. I mean, the gun is literally laying on top of where the drugs are in the defendant's pocket. The gun is, again, loaded. It's ready. It's accessible for use. And then I think I would also point this court.
But how is he using the gun because there is no facts from the district judge below? How are we to say that it was used to embolden or protect when he's in the middle of on a rural road, no one's around, and they're arguing incoherent?
For the same reason that the defense argued, the defense sort of explained his possession of a firearm in Kinston at night, in reference to him being a truck driver. And here, by the way, he's not in his truck, he's in his personal vehicle. But he's carrying the firearm, and it's to embolden and protect the drugs or to embolden and protect him as he's out in the world carrying that high value item. And I would also point the court to this.
Is there anything in the record as to what the value of the drugs was?
No, there's not, Your Honor.
Okay, and the record doesn't really even specify whether it was crack or powder cocaine. Isn't there some confusion there?
You're correct, Your Honor. It does not specify as to which it was. I think there was some testimony that it appeared to be crack cocaine by one of the officers.
But the difference, and this is again goes to, I don't mean to beat the dead point, but it goes to the fact the court didn't tell us what it was relying on.
I understand, Your Honor. I think, though, that the PSR identifies it as 3 grams of cocaine. That fact was not objected to, and the district court did adopt the findings of the PSR when it made its ruling on pages 57 to 58. I would also point the court to its own unpublished decision in United States versus Maddox. That was a case where the defendant had a gun and a small quantity of drugs on the floorboard of the car. Then he tried to escape. And the court basically said, under those circumstances, that it strains credulity to think that those two things are not related, given the circumstances where they're found.
But embolden, This court said that the potential for facilitation is so obvious that the court may confidently assume that the district court's fact-finding role. So don't we have to find that it's so obvious?
I think it's as obvious here as it was in Maddox. And I would also point the court to the fact that I think Bolden is a very different case and a helpful sort of contrast to the case we have here. In Bolden, the PSR had found that the facilitation was in furtherance of kidnapping. The district court rejected that because there wasn't enough evidence to see that it was that the defendant's conduct met the specific intent standard for kidnapping. And so the court just at sentencing made the decision that because the defendant also was in possession of a small amount of cocaine in the same room in a residence, that it would apply the facilitation just based on the cocaine. That wasn't part of the PSR. The parties didn't have a chance to address it in their sentencing memos. The defendant didn't have a chance to object to that. And also the court pointed out, well, in this case, we don't have what we had in Jenkins, which is someone out in the world with guns and a drug. We have drugs and a gun that happened to be in the same room as the defendant, and the district court didn't explain at all how those things could be related, whereas it's much more clear. It's again, strains credulity not to see how they're related in the context where someone is out in the world in a car with both of those things right next to each other. And if the court has no further questions on that, I would just ask the court to affirm.
We'll hear from counsel on rebuttal.
Brief rebuttal. Thank you, Your Honor. Just on this incoherent question, it's uncontroverted that up until the time they started screaming at him, yelling at him to try to wake him up, he wasn't incoherent. He was unconscious. He was unconscious this entire time until 10 seconds before he flailed his arms.
And why was he incoherent?
Because at this point, right, we also have to throw in he's intoxicated or high, and he's being roused from unconsciousness, probably with a blank stare on his face, doesn't know what's going on even 50 seconds later. But at this time, right, he is just coming out of total unconsciousness. And so that's why we say incoherent. The district court's ruling is on page 53 of the JA, and it's just absolute bare bones, as Judge Keenan pointed out, and it just puts this court in a difficult position because there's nothing to review.
What about the government's argument that the judge was very active during the hearing and questioning and that discussion? Should we consider the full transcript or just the ruling?
Oh, sure, but I just don't think it doesn't go to the material points. And as to the 4 level on the in connection with, again, we're just at C as to whether and how he thought there was facilitation. I can't see a possibility of facilitation here.
Do you agree that he accepted the PSR? Do you agree with the government on that?
He did adopt the findings of the PSR, but again, in the PSR, there are no findings about facilitation. So it can't substitute in terms of the 4 level. Now, as to the assault enhancement, there is the level of there's the language of the assault enhancement in the PSR itself, and he adopted that. But again, we objected to all those paragraphs about the assault, and we brought it forward, we put testimony on, and so at that point, it's the district court's independent duty to make findings, and the district court did not do that. So under Parker, the United States cannot supplement its evidentiary record on remand. We ask that this court vacate and remand for resentencing without the enhancements. Thank you for your time.
Thank you. We'll come down and greet counsel, but I'll ask the deputy to go ahead and adjourn court.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.